Joining us now, senior writer at Slate and co-host of the Amicus podcast, Mark Joseph Stern, historian, professor, and chair of African American Studies at Emory University, Carol Anderson, and director at the Center for Politics, editor-in-chief of the Crystal Ball, and author of Campaign of Chaos, Larry Sabato. All right, let's start with the legal part of this first. Mark, tell me what was argued in front of the Supreme Court today and where it appears the justices were likely to fall.
So lawyers argued that Louisiana violated the Constitution when it drew a second majority black district in order to comply with the Voting Rights Act. For decades, the Supreme Court has interpreted the Voting Rights Act to require these opportunity districts that have large black and brown populations so that these communities can elect the representatives of their choice. But today, lawyers argued that that is unconstitutional, that taking race into account to draw districts, even if it is designed to boost representation for minorities, even if it is designed to remedy past discrimination against minorities, that violates the Equal Protection Clause by considering race, and that the Constitution must be colorblind. And it sounded like a majority of the justices are leaning toward embracing some form of that argument, which would essentially dismantle the Voting Rights Act as we know it today.
How do you know that that's the way that they were leaning?
All six of the Republican-appointed justices indicated that they think that the Voting Rights Act has essentially outlived its usefulness. Justice Brett Kavanaugh continually said that there has to be a time limit on any race-conscious law and suggested that the expiration date for the VRA has arrived. Justice Barrett suggested that Congress went beyond what the Constitution requires in prohibiting these kind of racially skewed maps and that it couldn't be squared with the Equal Protection Clause. Justice Thomas, Justice Alito, Justice Gorsuch all indicated that protecting black communities by drawing race-conscious maps that give them more representation is actually racial discrimination, that it is unconstitutional because of the mere consideration of race. And so the law, again, as we know it, must fall. Now, I don't know exactly how the justices will decide to dismantle the law. They could interpret it differently. They could strike it down. But all six of them seem to be leaning towards some kind of result that would radically weaken, if not altogether demolish, what we know of the Voting Rights Act today.
So if this does happen, if it is overturned, if your assessment of where they're leaning is correct, let us show what could be impacted. This is a few maps showing VRA-protected congressional districts that could be affected. There's one in Louisiana, there is another in Alabama, and there is another in Texas. And those are the number of specific districts that could change. You see Florida in there as well, and a few other states. So, Larry, if this does get overturned, what are those races likely to look like?
Well, they'll be interesting because the current majority-minority districts will be broken up, will be so-called cracked, and you'll have portions of them going into redder districts so that Republicans living in other parts of the district presumably can overvote them and continue to elect the incumbents or the incumbents' Republican successors. Look, some estimates are already suggesting as high as 19 seats, Democratic seats lost if Section 2 is exploded by the Supreme Court. I don't think it'll be that high. I think it'll be more like a dozen. But when you combine a dozen lost seats for Democrats, if the Voting Rights Act Section 2 is struck down, with the redistricting that's going on around the country, pressured by Trump and pushed by the White House, that's going to produce a net gain for Republicans of 6, 7, 8 seats right there. And yes, I'm taking into account Proposition 50. I think it'll pass in California, +5 for Democrats, but there's +5 for Republicans in Texas. You put that together, and basically, you're going to normally have a Republican House of Representatives. It will take a strongly Democratic year, a wave year for Democrats like 2006 or 2018 in Trump's first term to get Democrats into a narrow majority. That's what it's going to do.
That's a really good assessment of the impact. Let me play Sonia Sotomayor arguing against overturning this. It appears she's arguing that. Here's her question.
What you're suggesting is that people of one race, blacks in Louisiana, who will have to be 51% of the population before they'll be able to elect another black candidate. Because what you're saying is partisanship is non-negotiable. You have to create maps where you're going to have 6 districts out of 7 always white, because that's our partisanship. That means blacks never have a chance, no matter what their number is, until they reach more than 51%.
Is that a correct assessment of what could happen, Carol?
Yes, it is, because partisanship is so linked to race right now, so that the majority of Republicans are overwhelmingly white. The majority of African Americans vote Democratic. And so that when you're saying that the population has to be over 51%, so she has really nailed it. And the notion that racism is no longer a function in our society just is undermined by their own decision that those who are Latino can be stopped simply because they are Latino and because they speak Spanish or because they have a low-wage job. I mean, so their own rationale is falling apart right in front of them.
Was this Voting Rights Act, this portion of it specifically, was it always intended to be something that lasts forever? Or was there a hope for a future where it was not necessary?
There was a hope that we would get to a point in our society where racism wasn't as trenchant as it was in the 60s. But when you think about it, we're still dealing with those kinds of fundamental issues. So after the Supreme Court gutted the Voting Rights Act, gutted Section 4 and therefore Section 5, the pre-clearance provisions of the Voting Rights Act, what that did was it let in a wave of laws designed to disfranchise the black population. And so we saw that with the voter ID laws. We saw that with the shutting down of polling places in black and poor communities. We saw that with the curtailing of the hours for early voting. And so this is what led several of the lower courts to say, you have targeted African Americans with almost surgical precision. And so it shows you the function of race in our election system. And so for the Supreme Court to argue that we really don't need a Voting Rights Act anymore is to ignore the function of race and racism in American society.
Give me a little bit more on the fundamentals there that you say are still an issue for us today, 60 years later after this was passed.
60 years later. So just think about the text that from the Young Republicans that in that Politico article that came out today that talked. So you heard the N-word over and over and over again. You heard the anti-Semitism. You heard the misogyny. And so those are from the Republicans who are moving on up in the tier. You saw it in terms of the way that ICE is targeting key people. You heard it in the election. So that Madison Square Garden event where you heard the kind of racism that was basically applauded and basically approved. So racism is viable and strong in American society, and to pretend that it is not. And so where we're seeing it in terms of our elections, we're seeing it in the ways that voter IDs were identified. So the kinds of IDs that whites particularly had, those were the kinds where you could access the ballot box. And the kinds of IDs that African Americans had, those were ignored. Those were the ones that the legislature said, those aren't viable to be able to vote. And so you saw it as well in terms of where they were shutting down polling places in the black communities. And what that was designed to do was to lower black voter turnout. And so we see this kind of pernicious, ongoing, insistent targeting of black voters, the black political power. How do we dilute that? And so we dilute it by creating these districts where you're saying you have to vote at large. And so the black vote gets dissipated in that larger voting population. And so what that is designed to do is to create a sense of disfranchisement, to create a sense of alienation, to create a sense that democracy just doesn't work. And so that is what racism did. And it is hearkening back to the days of Jim Crow.
Carol, really good to have you. Larry, you too. Mark Joseph Stern, as always. Thank you so much for starting us off and for helping us contextualize what we heard argued in front of the Supreme Court today, and also help us understand what exactly it's going to mean in certain races. All right, thanks.